Does Indian law engage with sexuality only in the context of sexual harms, like rape, sexual harassment, or sex trafficking? Or could it also have a conception of sexual pleasure? My search for an affirmative understanding of sexuality in legal discourse led me to the unlikeliest of places, namely divorce. In India, the most common method of obtaining divorce is to prove that one's spouse has treated them with cruelty. But the term cruelty itself is not defined in law. As a result, whether a spouse's conduct amounts to cruelty or not depends on the judge's understanding of what's tolerable and what's not in marriage. It is here that we find judges consistently agreeing that absence of sex and sexual pleasure in marriage is cruel and is a good reason to end the marriage. As opposed to other areas of family law, where we commonly encounter judges relying on a range of gender stereotypes, on this issue, we find them expecting the same behavior from both the husband and the wife. What's more, we also find judges acknowledging and even affirming the wife's sexual desire without conflating it with the desire for motherhood. Thus, for instance, in a 1970 case, two judges of the Calcutta High Court wrote, though the wife was keen for the husband's company, the husband kept her away on different pretexts. This indicates the husband's utter callousness and indifference to the wife. Or consider 1973 case decided by the Delhi High Court, where a woman who was married at 16 sought divorce after nearly 2 decades of unsatisfactory sex. Acknowledging that the husband tried his best to satisfy the wife, the judge wrote, every time the marriage bed, instead of being a source of pleasure and fulfillment, became a source of misery and frustration to the wife. The judge went on to grant divorce to the wife. Most judges take the relevance of sexual satisfaction to marriage to be self-evident. Take, for instance, the widely quoted line from a 1981 judgment by Justice Leela Seth of the Delhi High Court. A normal and healthy sexual relationship is one of the basic ingredients of a happy and harmonious marriage. In other cases, judges go on to give reasons as to why sex is important. Thus, in a 2016 judgment of the Rajasthan High Court, the judges wrote, sex improves immunity, heart health, blood pressure, and sleep, and contributes to the quality of life, the absence of which may well lead to depression and a feeling of lowered self-esteem, ultimately affecting the health and quality of life. There is some disagreement among judges as to whether divorce should be granted based on the objective criterion of absence of sex or the subjective criterion of sexual dissatisfaction. But generally speaking, most judges adopt a moderately affirmative attitude towards sex that deems it necessary for the pursuit of marital happiness. Furthermore, in holding that deliberately avoiding sex with a spouse amounts to cruelty and has legal consequences, judges acknowledge that sexuality is a site of power, especially in a relationship of economic and emotional dependency like marriage, and that power does not always show up as brute force. Despite this sensitive understanding of marital sexuality, the judicial discourse on the subject does not involve any mention of sexual consent. Thus, while judges affirm a normal and healthy sexual relationship in marriage, we hardly encounter consent as an ingredient of such a relationship. The issue of consent within marriage goes to the heart of the marital rape debate. Usually, the argument for recognizing marital rape is that women have the right to sexual autonomy and protection of bodily integrity even within marriage. Could we supplement this argument with the affirmative view of sexual pleasure that we find in the divorce cases? Could we argue that if marriage presupposes a happy, healthy sexual life for those in it, there is no way that consent cannot be a part of it?